This is Peggy Clary of Clary Law Offices. I am one of the estate planning attorneys at the firm, and today's video chat is really to talk about a significant trend that is happening within the state of Florida and someone in your family may also be undertaking. So that trend is leaving your home state and moving to Florida, either because of job change, retirement, you like the weather better, but as a state, Florida's had a huge infusion of residents moving into our state, declaring it their home state. The legal term is domicile. And then with that, those individuals are bringing estate planning documents from their old state. And a common question I receive is, I did this will plan in my home state of, we can pick one, Georgia, or I did this will plan in my home state of Massachusetts, and I've now decided to retire to Florida and live full time. Will Florida honor these documents? And that's a really good question, and the answer is pretty straightforward. Yes, if you are domiciled in Florida and you die with a will from another state, Florida will honor that will. However, Florida will disregard any provision under your old state's document that's in conflict with Florida law. And so I usually recommend for all clients that we take a moment and look at what documents are they bringing from the old state, because there are some subtle differences. It's some very prescribed rules under Florida law about who can serve as your personal representative of your estate. And so it's very important that when you are looking at these out-of-state documents, that you make sure they're going to comport or match with the rules of Florida law. And then also there's different ways to update, because sometimes that same client has spent a significant amount of money creating this plan and then recently decided to move. So you may not have to start completely over. You may be able to do what we call a codicil to the will. It's like I explain it as adding a second chapter in a book, but it's a good way to bring your document in line with Florida law without having to reinvent or start over. And then most importantly, if you have a trust, a revocable trust, that is a very good time to review, because trust documents often have clauses that are called administration clause or situs, which laws of which state will govern this trust document. And when you are changing domiciles, it usually is very beneficial to make sure where your trust is being administered is the state you're living in, because that's where your residence will be. You more than likely may hold bank accounts here. So it's very helpful to have a current document. And much like the will, you can amend a trust so you don't have to start completely over. So while you're unpacking your boxes and sending out, or at least emailing, your change of address cards, don't forget to have your estate planning documents reviewed by an attorney who is now in the state you're living in. You may not have to start completely over, but it's really important that your estate plan documents match the domicile in which you're living. So I hope this video was helpful to you. We wish you here from Clary Law a life of civility, dignity, and respect. And thanks again for your time.